Thank you for joining me. I'm here this morning to announce that I have made a formal request for a renewed investigation into the robocall election fraud of 2011. We know a lot about what occurred, but we don't know who was responsible. We know enough about what has occurred to demand that an investigation pursue the very clear findings of not one, but two different court judgments. Those court judgments are worth reviewing. They're worth reviewing together. And earlier this summer, I did that and then wrote a letter in September to the commissioner of the RCMP, the chief electoral officer, and the director of public prosecutions. Their response was to suggest that I needed to file a formal complaint to Monsieur Cote, the commissioner of Canada elections. And that is what I have now done. Je pense que l'enquête, c'est très important maintenant. Nous avons besoin d'enquête complète pour comprendre qui était la personne coupable, qui était la personne qui a la gestion, la responsabilité de gestion pour cet effort de changer les résultats des élections fédérales en 2011. C'est vraiment un cas de fraude. C'est clair que nous avons eu des crimes électoraux dans beaucoup de circonscriptions dans les dernières élections. So what do we learn from reading two different court decisions? And this is where I'm very concerned that we have not had a proper investigation. From the Court of Justice in the case against Michael Sona, we have findings that were released before the findings of Mr. Justice Hearn, released in August of 2014. And from May of 2013, we have the findings of Mr. Justice Mosley in what's called the Council of Canadians case. It's important to note that the Council of Canadians case dealt with 6 ridings, not including Guelph. The Michael Sona case dealt only with Guelph. We know that Mr. Justice Hearn, in viewing the evidence against Michael Sona, found that at most he was guilty of aiding and abetting. We know that the decision of Mr. Justice Hearn found that there was very likely, and in fact he found, as a matter of fact, other people were involved. In fact, Mr. Justice Hearn went to lengths to set out the ways in which the chief Crown witness who was granted immunity, Mr. Prescott, was more likely to have been more involved in this crime than the person who's now going to jail, Mr. Sona. We know from the case that was brought by numerous plaintiffs, and it's in general called the Council of Canadians case, but it was brought by plaintiffs from 6 different ridings across Canada, that the efforts of robocalls were coordinated, that it was organized. The fact that the message that was used, received in the phones of voters in dozens of ridings. We have these court cases deal with 7 of them, but we know that the number of complaints to Elections Canada far exceeds 7 ridings. We know that all of these ridings and all of these telephones received identical messages, identical wording in riding after riding. Tested as findings of fact by courts, we can say this for sure about 7 of them. We know from both judges that the voters who were phoned were voters who had an intention not to vote Conservative. That's a finding of fact from 2 different judges on 7 different ridings. And as a finding of fact by 2 different judges in 7 different ridings, we have that the likely source of the phone numbers used to contact voters who were not likely to vote Conservative was the Constituent Information Management System known as SIMS, owned and operated by the Conservative Party of Canada. These are findings of fact from 2 different courts. My request to Mr. Cote, and as I wrote earlier to the RCMP, Elections Canada, and the Director of Public Prosecutions, was to ask if they had interviewed every Conservative Party worker with access to the SIMS database. We know one worker who did not have access to that database, and that was Michael Sona. He had no access to the SIMS database. It seems to me that when a crime has been committed, a logical place to start is to interview all those people who had access to that database and find out if any of them can suggest how their database within the Conservative Party was used for multiple electoral crimes. Le scandale des appels robotisés a été une tentative coordonnée de frauder les votes des milliards d'électeurs lors des élections fédérales de 2011, ce qui peut avoir eu des répercussions importantes dans au moins 7 circonscriptions partout au Canada. Et si nous n'avons pas maintenant la vérité, qui était responsable, qui était coupable, j'ai peur que pour les prochaines électorales, les prochaines élections fédérales, nous avons un risque que la même chose va présenter encore. C'est un risque que les mêmes personnes qui maintenant sont libres, qui pensent qu'ils avaient gagné absolument discharge. C'est clair qu'à ce moment, actuellement, personne était sur surveillance. Personne maintenant faire face à la réalité que nous n'avons pas les réponses et la vérité ici. So if we don't get to the bottom of this, if we don't have the answers, there's no reason to think that even with the changes to management of robocalls when they're legal under the Fair Elections Act, there's no reason to think this won't happen again. We really must get answers. I'm hoping that with Mr. Cote's answer, which was there's no formal request, there's been no request for a full investigation. I'm hoping that with my formal request for an investigation, copies of which are available here, that we will have a renewed effort to find out who was responsible for elections fraud. Just want to make it really clear. How could we not follow up on the findings of 2 different judges in 2 different cases in 7 different ridings that found similar facts in each case? 2 different judges who independently of each other decided that the source of the phone numbers used was the Conservative Party database. How on earth in a democracy do the questions raised by this scandal end there with the conviction of one junior Conservative Party operative in one riding? It absolutely stinks to high heaven in a democracy if we let this end here. Thank you.
Ms. May, the Commissioner of Canada Elections has already conducted an investigation into complaints of something in the order of 1,300 or 1,400 robocalls outside of Guelph. And he concluded, in his report that was released after the Council of Canadians decision came out, and in a report that was endorsed by a former justice of the Supreme Court, that there was nothing there. That he could find no evidence of any kind of coordinated scheme. Why would this be different? Why are you expecting him, first of all, to open an investigation after he's already investigated that? And secondly, what would be different? Why would he come to a different conclusion now that you have a verdict in the Guelph case?
I think when you take the 2 decisions together, you know, it's absolutely stunning how similar the findings of fact were by 2 different judges examining 7 different ridings. The fact that the 2 different judges agreed that the likely source of the phone calls was the Conservative Party database is rather striking. And it seems to me that and I know that they've decided that they're leaving it alone and that it wasn't coordinated. But we have evidence of calls in multiple ridings. How could it not be coordinated? And we have the identical message in each of these different ridings. And we know as a matter of fact, now that the Sona trial has been concluded, and it's a finding of fact by the trial judge, Michael Sona didn't organize this. Now, if it's not coordinated, Mr. Cote can perhaps explain the magic that makes these not be coordinated. Identical calls in multiple ridings, not coordinated by Michael Sona, who had no access to the Conservative Party database and certainly wasn't ever an operative outside Guelph.
In Guelph, you're right that the judge did raise the possibility that two other people were involved. The commissioner's office has already said he's not investigating further. What do you think the problem is there? Well,
I can't begin to imagine what the problem is. The likely response from reading the decision of Mr. Justice Hearn is that since the person that he points to, Andrew Prescott, as having most likely the greatest involvement, was provided immunity for his testimony, that they didn't think there was any point in pursuing an investigation there because he was already granted immunity. I found Mr. Justice Hearn's ruling, I wish every Canadian would read it, to include things that were well beyond anything I'd seen in the media in terms of coverage of this issue. I was absolutely shocked in his summation of the likely reasons that I'm just looking for the right page number here. His summary of Mr. Prescott's evidence, and particularly his finding that here it is. It's at page 37 of the judgment, paragraph 6 of the subsection. Well, actually, paragraph 173, subclause 6. This is what he said about Mr. Prescott. Mr. Prescott was in charge of the computers set up within the office and also appears to have been active in obtaining the computers used on site together with his own laptop. Following the election, it was Mr. Prescott who wiped all the computers clean and had them destroyed at some point in time. And by the time he was interviewed, or at least contacted by Elections Canada, none of the computers continued to exist. The set of facts around the behavior of the chief crown witness, as I said, it's no wonder it was that, as Mr. Justice Hearn wrote, there certainly is some basis for the court being concerned Mr. Prescott was involved more so than he has indicated. Without being completely exhaustive of those reasons, they include the following. And then he lists numerous reasons that he thinks Mr. Prescott was more involved than Mr. Sona, including that he had all the computers set up, and he had the computers wiped clean, and he had the computers destroyed. I've never heard of a political campaign in my life that believes it's important to make sure the computers are destroyed at the end of the campaign. I think it's appalling that there has been no further investigation, even if Mr. Prescott can't be charged because he received immunity. But even more so, we have these other cases where nobody is disputing. I don't know how Mr. Cote's decision certainly and initial ruling can't dispute and did not dispute the findings of fact as set out by Mr. Justice Mosley, who found as a matter of fact that there was a coordinated attempt to defraud voters. We know that about these 6 ridings that were investigated and put before a court of law. If the if the system in Canada right now is prepared to, if the Commissioner of Canada's elections is prepared to ignore the findings of 2 federal court judges, I think that will speak very poorly of the powers of investigation that we have in this country to explore election fraud.
all the facts that you're referring to in those both decisions, these were all facts that the commissioner knew previously and knows now, and as yet has decided not to investigate. So you're not bringing anything new to the table to him for him to investigate. Why would you expect him to launch a new investigation when he's already decided that it's not required outside of Guelph, and in Guelph, the person that you're pointing the finger at, they has an immunity deal, so nothing's going to happen there.
What I understand Mr. Cote to have said was that there was no reason to pursue a complaint. He had no formal complaint. I'm lodging a formal complaint. I'm lodging a formal complaint because it seems to me when you read 2 different court cases dealing with 7 different ridings, not to mention that there were robocalls made in my riding in 2011. I wrote a letter of complaint. Nobody's ever come to interview me about any of it. I've never had a response email from Elections Canada or the Commissioner of Canada's elections. I have personal knowledge of election fraud attempts in my own riding, and I'm a member of Parliament, leader of a federal political party. I wrote a letter of complaint in May of 2011 about the number of robocalls in ridings across Canada. No one's even followed up to ask me a question. So I'm hoping that Mr. Cote will regard it as important that a member of parliament has filed a formal complaint, and I'm hoping that, because I don't know that he knew all the facts as disclosed by Mr. Justice Hearn in the court case in Guelph. If any Canadian citizen reads both of those court cases and doesn't think there's a reason for concern, then I'd be stunned. Frankly, there's a lot of information in those two court cases taken together that screams out for further investigation.
Given Mr. Cote's past statements about this, might there be another venue for investigation here that you would look at? That, I mean, if he's not going to look at it, should someone else?
Well, my initial approach this in September was to write to the superintendent of the RCMP, the commissioner of the RCMP, the chief electoral officer, the director of public prosecutions, and the commissioner of Canada's elections. I've been informed by those bodies that if I want a full investigation, that I can file a formal complaint and see where we go. If this is an office set up to whitewash electoral crimes, Canadians need to know that too. I'm hoping that's not the case. A formal complaint has been made with abundant evidence that comes from two different court cases. Plus, as I said, I had personal knowledge of electoral fraud in 2011. I wrote Elections Canada immediately after within 2 weeks of the election, as I got more and more complaints from across Canada. You know, it's
Letter to Cote?
yes, I do, and it's available here on the and I've also, as I mentioned, I do something unusual with the householders that most members of Parliament fill with pictures of themselves and send out to their voters. I do themed issues, and I was so stunned by what I saw when I read the two judgments side by side that I turned my last newsletter to all my constituents into a summary of what the judges found. And that's also available on my website as a parliamentarian. And I've been having a very strong reaction from voters. It happens that Saanich Gulf Islands was likely the first test of using robocalls to change the results of an election in the 2008 election campaign when I was not a candidate. But the voters of Saanich Gulf Islands, I can assure you, are very concerned about people getting away with electoral crimes in this country. It's a democracy. We used to send election observers to other countries. We still do. We still send election observers to other countries to help them run full, free, and fair elections. If we can't run one here, we're in real trouble. Merci beaucoup.